But more to the point, the Sussexes only will talk to people who repeat their own narrative.
Yes.
And who they can control.
They thought they had buried it forever. They were dead. Wrong. In the last 48 hours, Lady Colin, Campbell and Tom Bower have dropped a bombshell so devastating that Harry and Meghan's entire world is literally crumbling in real time. Secret documents, hidden identities.
She certainly did need to walk away with it without paying for it, because she doesn't make any money. She's not making any money off her was-never ventures.
A paper trail leading straight to their front door. The one thing they spent millions to keep hidden has just been handed directly to a court of law. And once you hear what is inside that envelope, you will never look at this family the same way again. On the morning of March 18th, 2026, Prince Harry, the Duke of Sussex, filed a defamation lawsuit in a legal office in California. The papers were signed, the process was set in motion, and within hours, the story had spread across newsrooms on both sides of the Atlantic. For Harry, the decision to pursue legal action appeared to be a calculated move, one designed to push back against claims that he and his wife, Meghan, the Duchess of Sussex, had long considered damaging and untrue. What followed, however, was not the straightforward vindication that many in his camp may have anticipated. Instead, the filing triggered a chain of legal events that observers and legal professionals have described as extraordinarily difficult to navigate, particularly for a couple whose public life has been built, at least in part, on a carefully managed version of events. Shortly after news of the lawsuit became public, Lady Colin Campbell, the author and commentator who has been one of the more persistent critics of the Duke and Duchess of Sussex, responded in a way that caught many people off guard. Rather than retreating or seeking legal counsel in a panic, she addressed the situation directly and with a notable degree of composure. Speaking on camera, she said simply that Harry was welcome to sue her. It was a brief response, but one that carried considerable weight among those who follow the mechanics of civil litigation closely. To a casual observer, it might have seemed like bluster. To those familiar with how defamation cases actually unfold in both British and American courts, it suggested something rather different. It suggested that Lady Colin Campbell was not afraid of what a legal process might uncover. The reason for that confidence lies in a specific legal mechanism that comes into play the moment a defamation claim is filed. That mechanism is called discovery, and it is, in the simplest possible terms, the phase of a lawsuit where both sides are legally compelled to share evidence. It is not optional, and it is not something that can be easily avoided once the process has begun. Discovery means that private correspondence, internal communications, medical documents, financial records, and any other material deemed relevant to the case can be requested, examined, and in many instances brought into open court proceedings. For individuals who have gone to considerable lengths to keep certain aspects of their lives out of the public domain, the discovery process represents a genuine and serious threat. This is a point that legal commentators have raised repeatedly in the days following Harry's filing. By initiating a defamation claim, the Duke of Sussex has, under the rules of civil procedure, handed the defence the legal right to request documentation that he would almost certainly prefer to keep private. That is not a consequence of bad luck or poor timing. It is simply how the law works. A person who files a defamation case is, in effect, placing their own version of events under scrutiny. If they claim that a particular statement about them is false, they must be prepared to prove it, and to do so using evidence that holds up in a courtroom rather than in a press release. The discovery process, as it applies to a case of this nature, tends to work in several distinct stages, each of which carries its own risks for the party who initiated the claim. The first of these is the mandatory disclosure of relevant materials. If Harry is arguing that specific reporting about his family or his personal life is inaccurate, he is legally required to provide the documentation that supports his version of those events. That means private text messages, emails, and any other written communications that touch on the matters being disputed could become part of the evidentiary record. It is a broad and often uncomfortable process, and it applies equally to both sides. But the burden of proof in a defamation case sits primarily with the person making the claim. The second stage involves what is known as third-party disclosure, or the compulsion of records held by organisations that are not directly party to the lawsuit. Under discovery rules, the defence can issue subpoenas to hospitals, clinics, financial institutions, and other bodies requesting records that are relevant to the case. Those institutions are generally bound by law to comply. This is a particularly significant dimension of the current legal action, given that some of the claims Harry is seeking to challenge relate to events that took place in medical settings. Hospitals keep detailed records, and those records, once subpoenaed, become part of the legal process regardless of whether the individuals involved would prefer they remain confidential. The concept of privacy as it exists in everyday life does not translate directly into a civil courtroom. The third stage is the deposition, and it is arguably the most consequential of all. A deposition is a formal session in which a witness or party to a lawsuit is questioned under oath by the opposing legal team. These sessions can last for several hours, and the questioning can be exhaustive. Everything said during a deposition is recorded and can be used as evidence. More importantly, making a false statement during a deposition is not simply a reputational matter. It constitutes perjury, which is a criminal offence in both the United Kingdom and the United States, the Sussexes. Consequences of a perjury conviction are serious and, in some circumstances, irreversible. For individuals who hold titles, public positions, or commercial relationships that depend on their standing and credibility, the stakes in a deposition are extraordinarily high. Investigative author Tom Bower, whose work has focused heavily on the Duke and Duchess of Sussex in recent years, has indicated in various interviews that he and his team have assembled a substantial body of evidence. Bower, who has a long track record of investigative journalism covering powerful figures in business and politics, has suggested that the material he has gathered is detailed and specific enough to withstand the scrutiny of a formal legal process. He has also indicated that the scope of the investigation extended well beyond publicly available information, encompassing records that required considerable time and resources to locate and verify. The financial dimension of the Sussex operation is also relevant to understanding why the discovery process carries the weight that it does. Reports from multiple outlets suggest that the Duke and Duchess of Sussex have spent considerable sums over the past several years on legal measures designed to protect their privacy, including injunctions and digital security arrangements. The figure cited in various investigative reports runs into the tens of millions of dollars. That level of expenditure suggests a significant and sustained effort to control the flow of information. When a legal process like discovery is triggered, those protective measures do not disappear overnight, but their practical effectiveness is substantially reduced. Material that has been kept out of public view through legal mechanisms can, under the right circumstances, become subject to court orders that override those protections. What makes this particular legal moment so significant is not simply the scale of the potential consequences, but the timing. The Sussex brand, as it has come to be known in media and business circles, is built on a foundation that includes their titles, their public image, and the various commercial partnerships they have entered into since leaving their roles as senior working members of the royal family. That brand has considerable financial value, but it is also dependent on a version of their story that has, until now, been largely told on their own terms. A legal process as invasive and transparent as discovery does not allow for that kind of editorial control. It is governed by rules, not by public relations strategy, and it proceeds on a timeline set by the court rather than by the preferences of the parties involved. As of now, the lawsuit is in its early stages and no depositions have yet taken place. But the clock is running. Legal observers on both sides of the Atlantic are watching closely, not only because of who is involved, but because of what the process itself may eventually bring to the surface. The decision to file has been made and it cannot easily be undone. What happens next will be determined not by press statements or social media posts, but by documents, testimony, and the slow, methodical workings of the law. To understand why the legal process now underway carries such significant weight, it is necessary to look at the specific claims that sit at the heart of the investigation. These are not abstract allegations. They are rooted in a detailed examination of a particular set of events that took place in London in the early hours of May 6, 2019, the day on which the birth of Archie Harrison, the first child of the Duke and Duchess of Sussex, was announced to the world. What began as a series of observations made by journalists and commentators has, over the course of several years, developed into a formal body of investigative material that is now being cited in legal proceedings. The questions being raised are specific, the timeline has been examined in considerable detail, and the Anomalies that investigators say they have identified are, according to those involved, not easily explained away. The setting for this part of the story is the Portland Hospital on Great Portland Street in central London. The hospital is well known for catering to high-profile clients and carries a price tag that reflects its reputation. It was here, according to the official account released by the palace at the time, that Meghan, the Duchess of Sussex, gave birth to her son. The announcement was made in the afternoon of May 6th, with a palace statement confirming that the Duchess had gone into labour in the early hours of the morning. That statement was released at approximately 2 o'clock in the afternoon. However, the official record states that the child was born at 5:26 in the morning. That creates a gap of several hours between the time of the birth and the time at which the public was told that labour had begun, a sequencing that a number of observers have described as unusual and, in the context of royal protocol, without clear precedent. To those outside the world of royal tradition, this might seem like a minor administrative detail, but within the framework of how royal births have historically been managed and communicated, the timing of announcements carries real significance. Transparency around the birth of a royal child is not simply a courtesy extended to the public. It is part of a broader system of verification that has been in place for generations, designed to ensure that the identity and legitimacy of royal heirs are beyond question. When that system produces what appears to be a deliberate gap in the information provided to the public, it raises questions that are difficult to dismiss without a satisfactory explanation. Investigative author Tom Bower and his team spent a considerable amount of time examining the operational records and surrounding documentation related to that specific morning at the Portland Hospital. What they reported finding was a procedural picture that, they argue, departs significantly from established royal practice. For well over a century, the birth of a royal child in the United Kingdom has been attended by palace-appointed physicians, and the involvement of those physicians has been formally recorded. Their signatures appear in the official birth register as witnesses to the event. It is a process that exists precisely to provide an unambiguous and verifiable record of the circumstances of a royal birth. In the case of Archie Harrison, Bower's team has stated that this process does not appear to have been followed in the standard way. Specifically, they have reported that no verifiable signature from a royal medical consultant appears on the primary hospital record for the relevant delivery room on that date. The name most frequently associated with the medical oversight of the birth was that of Dr. Laura Manell, a consultant who had been involved with the Duchess during her pregnancy. However, according to Bower's investigative findings, attempts to confirm the formal documentation of her involvement in the delivery itself produced results that he and his team describe as inconclusive. That is a notable finding, given the historical precedent for how such records are maintained and the level of scrutiny that surrounds any birth connected to the royal family. The linguistic dimension of the story is one that Lady Colin Campbell has drawn particular attention to, and it is worth examining in some detail. In both the official announcement of Archie's birth and the subsequent announcement relating to the birth of Lilibet Diana, the second child of the Duke and Duchess of Sussex, the phrasing used a particular construction that Campbell and others have argued is significant. The announcements referred to the children as having been born for the Duke and Duchess of Sussex, rather than the more traditional phrasing born to the Duke and Duchess. This distinction may appear trivial to a general reader, but in the context of English common law and the conventions of aristocratic record-keeping, the two phrases carry different meanings. Born traditionally denotes a biological birth by the mother, named in the announcement. Born for is a construction that has historically been associated with arrangements in which a child is delivered by one party and received by another. The use of this phrasing on two separate occasions, across two different births and two different jurisdictions, is something that Campbell has consistently argued warrants explanation. Whether it represents a deliberate choice of words, a legal formality, or simply a clerical error is one of the questions that has never been directly addressed by the Sussexes or their representatives. The investigation also focused on the physical logistics of the morning in question at the Portland Hospital. For any member of the royal family attending a public medical facility, the security consent arrangements required are extensive and well established. A visit of this nature would typically involve a pre-cleared security sweep by officers from the Metropolitan Police, the arrival of a security detail, and the use of a designated secure entrance to the building. These are not optional measures, they are standard protocols that exist to protect members of the royal family and to ensure the safety of other patients and staff at the facility. According to the findings reported by Bauer's investigative team, a review of the hospital's entrance records for the relevant 4-hour window surrounding the birth produced no evidence of the kind of security activity that would be expected for a royal admission. Specifically, there is reported to be no record of a private motorcade or a security detail matching the profile of a Sussex visit arriving at the hospital's secure entrance on Devonshire Street during that period. For many people, this will seem like a minor logistical point, but it is worth considering what it would mean in practice for a member of the royal family to arrive at a busy central London hospital without the standard security arrangements in place. It would represent a serious deviation from the protocols that exist for reasons of personal safety and national security. The absence of any record of those arrangements is, according to those who have studied the timeline, one of the more difficult aspects of the official narrative to reconcile with standard royal practice. Taken individually, each of these points, the timing of the announcement, the question of the medical documentation, the linguistic choices in the birth notices, and the apparent absence of security records, might be set aside as the result of unusual circumstances or administrative oversight. Royal births are complex events, and it is not unreasonable to suggest that some degree of deviation from standard practice might occur. But investigators and legal commentators have pointed out that the cumulative picture presented by these anomalies is harder to explain away. When multiple elements of an official account appear to conflict with established precedent and verifiable records, the questions they raise become more difficult to ignore, particularly in the context of a legal process that is specifically designed to test the accuracy of official accounts. This is precisely why the discovery phase of the current lawsuit has the potential to be so consequential. Harry cannot, in the context of a formal legal proceeding, simply decline to address these questions. If his defamation claim rests on the argument that reports about the circumstances of his children's births are false, he is legally required to provide documentation that supports that argument. That means producing the original, unredacted hospital admission records and providing a coherent explanation for the elements of the timeline that investigators have identified as inconsistent. The court is not interested in narrative. It is interested in evidence. What the investigation into the events of May 6, 2019 has produced is not a conclusion. It is a set of specific, documented questions about a timeline that, according to those who have examined it most closely, does not hold together in the way that an official account of a royal birth should. The palace has not publicly addressed these specific points in any detail. The Sussexes have not offered an explanation for the anomalies identified in the hospital records and security logs. That silence has done nothing to reduce the pressure that is now building through the legal process. If anything, it has increased. The court has a timeline. The clock is running. And the questions that have been circulating for several years now have a mechanism through which they may finally receive a formal answer. As the legal proceedings continue to develop, the focus of the investigation shifts away from hospital records and official timelines and moves toward a category of evidence that is, in some respects, more immediately accessible to the general public. This is the visual record of Meghan's pregnancy, the thousands of photographs and hours of video footage captured by professional photographers and television crews during the period between late 2018 and the spring of 2019. It is a body of material that has been examined closely by investigators, and the conclusions drawn from that examination have become a significant part of the broader case being assembled by those who have questioned the official account of events. The starting point for this part of the investigation is a body of forensic image analysis commissioned by Tom Bauer's team, which reportedly reviewed in excess of 3,000 high-resolution photographs alongside several hundred hours of video footage from the relevant period. The purpose of that review was not to make a subjective judgment about the Duchess of Sussex's appearance, but to apply a consistent and measurable analytical framework to the visual material, looking for anything that could not be explained by ordinary biological processes. What the team reported finding was a series of inconsistencies that medical professionals and forensic analysts consulted during the investigation described as difficult to reconcile with a standard biological pregnancy. One of the earliest and most frequently cited examples relates to an appearance at the British Fashion Awards, held at the Royal Albert Hall in London on the evening of December 10, 2018. At this point in the timeline, Meghan was understood to be in the later stages of her pregnancy. She appeared on the stage in a black one-shoulder gown and, over the course of the evening, was photographed repeatedly with both hands placed firmly against her abdomen. This gesture was widely interpreted at the time as a natural and affectionate expression of a mother-to-be's connection with her unborn child. However, analysts who reviewed the footage in detail have offered a different interpretation. According to maternity wear designers and forensic image specialists consulted by the investigative team, the placement and pressure of the hands appeared to serve a structural rather than an emotional function. More specifically, they pointed to what they described as a phenomenon called manual stabilization, in which a person applies pressure to an external object to prevent it from shifting or moving. The same analysts also noted that the fabric of the dress, when examined in high definition, did not behave in the way that would be expected if it were covering a natural pregnancy bump at that stage of gestation. A genuine third trimester pregnancy produces a rounded, fluid-filled shape that moves in a particular way when a person changes position or shifts their weight. The footage from that evening, according to those who reviewed it, showed creasing and geometric indentations in the fabric that they argued were more consistent with the surface of a firm synthetic material than with the soft, organic contours of human tissue and amniotic fluid. A retired midwife with more than 30 years of clinical experience in labour and delivery, who was asked to review the footage as part of the investigation, stated that a natural pregnancy bump at that stage does not change its centre of gravity or alter its shape when the mother changes her posture. The footage, she indicated, appeared to show exactly that kind of movement. The second significant incident in the visual record took place on January 14, 2019, during a public engagement in Birkenhead on Merseyside. Meghan attended the visit wearing a purple dress beneath a red coat, and photographs from the morning of the engagement captured what appeared to be a prominent, high-set pregnancy bump. By early afternoon, following a private lunch break, photographs taken later in the day told a different story. According to the analysis conducted by Bauer's investigative team, the apex of the bump, meaning the highest visible point of the abdomen, appeared to have shifted downward by a measurable distance between the morning and afternoon appearances. The team stated that digital mapping techniques applied to the photographs produced a figure of approximately 3.2 centimeters. This finding is significant because of what it implies from a medical standpoint. In the third trimester of a biological pregnancy, a baby does not descend and then returns to a higher position within a matter of hours. The process of a baby dropping, which refers to the natural movement of the fetus downward into the pelvis in preparation for birth, is a gradual process that takes place over days or weeks, not within a single afternoon. A shift of the kind identified in the Birkenhead photographs, if the measurements are accurate, is not consistent with any known aspect of normal fetal development. The investigative team has described this as one of the more compelling pieces of visual evidence in the dossier, arguing that it points toward a failure or partial displacement of an external prosthetic device rather than any natural change in the physical condition of the Duchess. The third and perhaps most widely discussed visual event in this section of the investigation took place during a visit to the Mayhew Animal Charity in London. At this point in the timeline, Meghan was reported to be approximately 8 months pregnant. During the visit, she was photographed performing a full squat to interact with a dog at ground level. The squat was deep and unassisted, performed with her knees pressed together and her weight shifted forward over her feet. She then stood back up without using her arms for support, while wearing shoes with a heel height of approximately 12 centimeters. The reason this moment attracted such intense attention from medical professionals is straightforward. At 32 weeks of pregnancy, the human body is carrying a significant additional load concentrated in the abdominal area. The weight of the fetus, the placenta, and the amniotic fluid creates a physical displacement of the body's natural center of gravity that makes certain movements genuinely difficult and, in some cases, unsafe. Orthopedic surgeons and obstetric consultants who reviewed the footage as part of the investigation stated that a deep squat of the kind performed by Meghan, with the knees in a closed position and the center of gravity shifted forward, would present serious practical challenges for a woman in the third trimester of pregnancy. The pressure placed on the lower spine and pelvic floor at that stage of gestation, combined with the significant change in balance created by a pregnancy bump, makes standing up from that position without arm support extremely difficult. Several of the medical professionals consulted described the movement as inconsistent with what they would expect to observe in a patient at that stage of pregnancy. The theory put forward by investigators to explain the pattern of behaviour observed across these and other public appearances is that the constant hand placement that characterised so many of Meghan's public engagements during this period was not a gesture of maternal affection, but a practical measure. Prosthetic pregnancy devices, of the kind used in the film and television industry, are constructed from medical-grade silicone and are worn using an adhesive or harness system. They are highly realistic in appearance but require a degree of active management to prevent movement, noise, or visible displacement, particularly during physical activity or when a person sits and stands repeatedly over the course of a long public engagement. Investigators have suggested that the hand placement served to maintain the position of such a device and to prevent any sounds or movement that might attract attention. The palace, according to reports from the period, was itself aware of the growing volume of commentary around the visual inconsistencies. A briefing involving senior aides reportedly took place in late January 2019, with the visual presentation of the Duchess during her public appearances listed as a subject of internal concern. The response, according to those familiar with the situation, was to treat any public questioning of her appearance as a matter too sensitive to engage with directly, framing it as an attack on her personal well-being or as an expression of prejudice. That approach may have been effective in a public relations context, but it does not translate into a legal one. In a courtroom, the analysis of photographic and video evidence is governed by rules of admissibility and expert testimony, not by the social dynamics that shape public debate. Tom Bower has stated that he has compiled a list of medical professionals, including consultant obstetricians, who are prepared to give formal testimony regarding the visual record. If that testimony is admitted, the court will be asked to consider whether the evidence captured in those thousands of photographs and hours of footage is consistent with a biological pregnancy, or whether it points to something else entirely. The outcome of that consideration could have consequences that extend well beyond the reputations of the individuals involved. The investigation now moves into territory that goes beyond the personal and the procedural and enters the realm of constitutional law, financial accountability, and the long-term structural implications for one of the world's most recognizable institutions. The questions raised in the earlier stages of this story about hospital timelines, medical documentation, and the visual record of a pregnancy are serious in their own right. But the consequences that flow from those questions, if the evidence is found to support them, operate at an entirely different level of significance. This is where the story stops being about a celebrity dispute and starts being about the legal foundations of the British monarchy itself. At the centre of this final phase of the investigation is one of the oldest pieces of constitutional legislation still in active force in the United Kingdom. The Act of Settlement of 1701 was passed by the British Parliament more than 3 centuries ago and remains, to this day, a foundational document in the framework of the British state. Among its provisions is a requirement that is directly relevant to the questions being raised about the Duke and Duchess of Sussex. The Act specifies that a child must be born of the body of the mother in order to be eligible for royal titles and a place in the line of succession. This is not a guideline or a convention that can be interpreted flexibly depending on the circumstances. It is a hard legal requirement, and it was written with precisely the intention of preventing any ambiguity around the legitimacy of royal heirs. The implications of this requirement in the context of the current legal proceedings are significant. If the discovery process in the defamation case produces evidence that Archie Harrison and Lilibet Diana were not carried and delivered by Meghan, the Duchess of Sussex, but were instead born via a gestational surrogate, then regardless of whether they are the biological offspring of the Duke and Duchess in a genetic sense, they would not meet the born of the body requirements set out in the Act of Settlement. Under that legislation, the King would be constitutionally compelled to act. The College of Arms, which is the official authority on matters of royal lineage and heraldry in the United Kingdom, would become involved in a formal review process. The Privy Council would need to receive a formal challenge to the legitimacy of the birth records. A forensic investigation would be initiated. And if the born of the body requirement were found to be unmet, the monarch would be required to issue a letters patent, formally removing the children from the line of succession and stripping them of their princely status. It is worth pausing to consider what that would mean in practical terms, not just symbolically, but financially. The Sussex brand, as it has been constructed and marketed over the past several years, is built on a specific set of foundations. Chief among those foundations is the royal connection, the titles, the lineage, and the status that comes with being high-ranking members of the House of Windsor. That status is not merely a matter of prestige, it is the commercial asset on which a series of major financial agreements have been built. The reported deal with Netflix, valued at approximately $100 million, was entered into on the basis of who Harry and Meghan are and what they represent. The same is true of their publishing contracts and their other commercial partnerships. If the titles are removed, the basis on which those agreements were made changes fundamentally, and the contracts themselves may contain provisions that allow the other party to seek remedies. Many high-value media and commercial contracts include what are known as morality and authenticity clauses. These are provisions that allow a corporation to terminate an agreement and, in some cases, to demand the return of funds already paid, if the subject of the contract is found to have engaged in fraudulent misrepresentation or serious public deception. If it were established through legal proceedings that the Sussexes had presented a biological pregnancy to the world as part of a broader commercial narrative, while simultaneously entering into private arrangements of a different kind, those clauses could be activated. The financial consequences would be severe. Reports suggest that the advance payments already received under certain agreements run into the tens of millions of dollars. A clawback of those funds, combined with the legal costs of ongoing litigation, could place the Sussex finances under extraordinary pressure. The financial picture is further complicated by what investigators describe as a payment trail that predates the public announcements of the pregnancies. According to reports based on documents reviewed by the investigative team, a payment was made in late 2018 to a legal and medical consultancy based in the state of Oregon. The figure cited in those reports is $150,000. Oregon is notable in this context because of the legal framework it provides for surrogacy arrangements. The state has some of the most permissive surrogacy laws in the United States, allowing for a high degree of anonymity and, crucially, permitting the intended parents to be listed on the birth certificate at the point of delivery without the biological verification requirements that apply in other jurisdictions. Investigators have argued that this makes Oregon a logical choice for anyone seeking to arrange a surrogacy while minimizing the documentary evidence that would normally accompany such an arrangement. Whether the payment identified in those records is directly connected to a surrogacy arrangement is something that has not been established in a court of law. But the existence of the payment and the nature of the consultancy to which it was reportedly made are among the specific pieces of evidence that legal teams are understood to be examining as part of the discovery process. This is the kind of detail that a civil lawsuit is designed to bring to the surface. Financial records, wire transfers, and contractual agreements leave traces that are difficult to erase entirely, and the legal mechanism of discovery gives the opposing side the tools to follow those traces wherever they lead. Looking at the possible outcomes of the legal proceedings as they now stand, those close to the case have outlined several distinct scenarios, each with its own set of consequences. The first and most far-reaching possibility is that the discovery process yields documentary evidence sufficient to establish, in legal terms, that the children were not born of the body of the Duchess of Sussex. Under that scenario, the constitutional machinery described above would be set in motion, and the removal of titles and succession rights would follow. The commercial consequences would be immediate and extensive. The second scenario involves the Sussexes losing the defamation case on its merits, without the surrogacy question being definitively resolved. In that event, the financial penalties alone could be substantial, and the reputational damage resulting from a public legal defeat would have its own knock-on effects for their commercial relationships. The third scenario, which has been described by some legal observers as the most probable, involves a more personal reckoning for the Duke of Sussex himself. There is a possibility that Harry, faced with the prospect of the discovery process exposing information that would be deeply damaging to his own standing within the royal family, might choose to distance himself from the legal strategy currently being pursued. That could mean withdrawing the lawsuit, or it could mean something more significant in terms of his personal and family arrangements. The pressure created by the legal process does not fall equally on both parties. Harry's position within the line of succession and his relationship with the institution of the monarchy give him a set of considerations that are distinct from those facing Meghan, and those considerations may ultimately drive his decision-making in ways that are difficult to predict from the outside. Perhaps the most striking development in the final stages of this investigation is the reported emergence of new physical evidence. According to sources cited in the investigative reporting, Lady Colin Campbell recently received a document package containing a copy of a flight manifest from April 2019 and a signed affidavit from a former member of staff who worked at the Portland hospital. The affidavit reportedly identifies a woman who was admitted to a private wing of the hospital under a pseudonym at approximately the same time that Meghan was said to be in labour. The woman identified in the document was not connected to the royal family. She was, according to the affidavit, a young woman in her mid-20s who had travelled to London from Oregon several days before the birth was announced. She departed the United Kingdom on a private flight within hours of the announcement being made. The significance of that detail, if it is verified, is obvious. It does not by itself constitute proof of anything. A document of that kind would need to be authenticated, the affidavit would need to be tested, and the individual named in the manifest would need to be identified and their account of events examined. But as a piece of potential evidence in the context of everything else that has been assembled by the Hunt's investigative team, it is a development that the legal teams on both sides will be taking seriously. What this entire investigation ultimately comes down to is a question of documentation and accountability. The Duke and Duchess of Sussex have built a public identity that is, in significant part, a constructed narrative. That is not unusual in public life. But the legal process now underway does not respond to constructed narratives. It responds to documents, testimony, and verifiable records. The Act of Settlement does not make allowances for personal truths or carefully managed stories. It sets out a requirement, and that requirement either is or is not met by the facts of the situation. The discovery process will determine which of those is the case, and when it does, the consequences, whatever they turn out to be, will be a matter of public record rather than private management.